I'm going to work on some pancakes here while I talk about how the Supreme Court handled McCain-Feingold. The law, the Bipartisan Campaign Reform Act, was passed in 2002 by Congress, and it was signed by President Bush. That same year, it became law. A lot of his supporters were surprised by that. They thought that President Bush would veto the act because of the First Amendment concerns. The gossip was that President Bush, in fact, did not like the law, but he assumed the Supreme Court would strike it down. He didn't want to pick a fight. He didn't want to pick a fight with John McCain. If the gossip was right, President Bush was wrong. The Supreme Court loved every inch of this law. In a court decision entitled McConnell versus FEC, and that will be the same McConnell as Mitch McConnell, Kentucky senior senator, the Supreme Court held this law to be constitutional. What was the court thinking? Well, mainly Buckley versus Vallejo. And Buckley versus Vallejo was that 1974 Supreme Court case that upheld the last big Campaign Finance Reform Act. And the key concept is that the government has a legitimate interest in limiting corruption in the election process, the idea being, let's protect the democratic process. But once you've said that, you still need to limit the limits. And that's where a standard comes into play. Typically with First Amendment cases, the court will use a standard that's referred to as strict scrutiny or exacting scrutiny. And that means that you almost have a bias against the law. Somebody really has to prove to the court that the burdens on our rights are really worthwhile. The court in this case did not go with that standard. They went with a standard referred to as closely drawn. And that just means that the law has to be closely drawn or closely related to what you're trying to do in order to pass constitutional muster. Why did they go with that looser standard? Well, as I've already said, they had approved this idea that the government can limit our constitutional rights if there's a legitimate interest there. That legitimate interest being, let's limit corruption in our electoral process. But there was another reason they went with that looser standard, and that's because the Supreme Court trusted Congress to make election law. They wrote that Congress has a lot of expertise in election law, so we need to defer to them in this particular case. With that said, with that decided, it's pretty much just a matter of going through the provisions of the law and saying, well, does this limit corruption? Does it limit undue influence? Does it limit a situation where you have a contributor who meets with a congressman? You have a contribution for a vote or a vote for a contribution. I think of all the provisions in Titles 1 and 2, only one provision was struck down by this court. The dissenters, the guys who thought that McCain-Feingold was unconstitutional, Scalia, Thomas, Kennedy, and the late Chief Justice Rehnquist. They hit on all aspects of the majority opinion and then some. Scalia goes after the incumbents. He feels that it's no accident that the provisions in this law help incumbents. Take soft money, for example. It conveniently shuts off the spigot to a poorly funded incumbent. Scalia he doesn't really buy the whole corruption thing, and he's kind of tired of politicians saying things like, there's too much money in politics. Well, he does some digging, and he finds out that in the year 2000, when the latest figures were available, if you take the highest figures he could find, Americans spent about $3.9 billion on elections. That's about half the amount of money we spent on movie tickets. Scalia's point, there's not that much money in politics. And Scalia winds up his dissent with this idea that politics is already regulated, it's already complicated, it's already intimidating. That could undermine the democratic process. Clarence Thomas is just amazed that the court will bend over backwards to protect the free speech rights of child molesters, neo-Nazis, cross burners, but the court won't protect political speech, the speech that actually is at the core of our democratic process. Clarence Thomas also makes a really interesting observation about this idea of circumvention. He starts by saying, Buckley versus Vallejo. The court approved the Federal Election Commission Act because it felt that the bribery laws already on the books were not being observed. They were being circumvented. So you have FECA. Well, then FECA gets circumvented. We find a couple of loopholes in FECA. Soft money and issue ads. So then we get McCain-Feingold. Well, what if there are loopholes in McCain-Feingold? What if people start to circumvent McCain-Feingold? Will we have more law? Will we have more regulation? Scalia wants to know, where is it going to end? I mean, not Scalia, Thomas. But like Scalia, he also doesn't buy this whole corruption thing. He even goes after John McCain, because in court papers that Senator McCain filed for this case, Senator McCain draws a connection between certain amendments that he proposed that were defeated and soft money. And Clarence Thomas just kind of offers the suggestion, well, maybe those amendments were defeated because they lacked public support. Maybe the amendments were defeated because they were bad law. Kennedy's dissent is really long and really complicated. Like Scalia and Thomas, he doesn't like this law. He bluntly calls it the Incumbent Protection Act. But whereas Scalia and Thomas really kind of hit hard on Buckley versus Vallejo, they think Buckley versus Vallejo was decided incorrectly. Kennedy says, no, let's play by the rules set down in Buckley versus Vallejo, that the government has a legitimate interest in limiting corruption, so much so that they can actually burden or restrict our First Amendment rights. Kennedy's issue is just show me the corruption. And by corruption, he uses a Latin term, quid pro quo, that translates roughly as I'll scratch my back, you'll scratch yours. I'll scratch your back, you'll scratch mine, in exchange of favors. A contribution for a vote for a contribution. Kennedy says all the stuff the majority opinion is talking about, this undue influence, may be corruption or maybe it's just politics. Yes, you could have a fat cat contributor meeting with a congressman. And yes, you could have a congressman voting the way that contributor wanted him to vote. But maybe the congressman voted for the law because his constituents backed it. Maybe the congressman voted for the law because all of his other contributors said so. Maybe the congressman voted for the law because it was good law. Kennedy is just not happy with this idea that the majority court opinion approves restrictions when there may or may not be that connection. There may be a quid, but there's no pro. Maybe there's a pro, but no quid. And without that connection, Kennedy says there's just no limit to what Congress can do in terms of putting burdens on our First Amendment rights. Rehnquist kind of says the same thing, but like in a couple of pages. He hits the circumvention idea, and he's very much into this idea that just because you have two people meeting, that's not necessarily corruption. He thinks that the court is a little two-faced. On one hand, the court defers to Congress, and the court says, well, Congress really has a lot of expertise in elections, and we trust them to make good election law. But on the other hand, it approves regulations like banning soft money because congressmen are too stupid or too easily manipulated to be in the same room with a big contributor and not do exactly what the contributor tells them to. Rehnquist has a really interesting question. He says, what's more corrupt? A Congress that passes law that gives incumbents a leg up, or soft money that may or may not influence a vote? Bottom line, the dissenters feel this is not a law about corruption in politics. It is a law without limits.